Welcome back to this session. We have several directions which I'll read through. And the first direction is in respect of the issue which was raised by Counsel Mr. Muge regarding the applications in the Kerugoya matters. The bench directs that these applications have been overtaken by events following the ruling before the following the judgment by the Court of Appeal and the ruling by this court. What is pending in those petitions are the substantive petitions. Second issue or direction relates to petition number E599 of 2024, which is not part of these consolidated petitions. And as rightly noted by Counsel, this petition, having not been consolidated, shall proceed on its own. The petition shall come up for directions on the 9th of October 2025 at 2:30 p.m. and learned counsel for the petitioners is hereby directed to serve the rest of the parties with a mention notice. Direction number 3. In view of the directions given in respect of the Kerugoya matters and the need to accord parties the latitude to fully present their cases before this court, we hereby grant petitioners or any of them leave to amend their respective submissions within, their respective petitions within 14 days of today. The respondents will equally amend their respective responses within 14 days of service if need be. Thereafter, the petitioners shall file and serve their written submissions, including list of authorities, within 14 days of service of the responses above. The respondents and the interested parties shall then file and serve their written submissions within 14 days of service. Leave is granted to the petitioners to file their rejoinder submissions within 7 days of service of the submissions by the respondents and the interested parties. Now, leave time is of essence in these directions, and any defaulting party will just have to suffer the consequences of default. After the parties have filed their respective submissions, parties will appear before this court on 2 days for highlighting of their submissions. Day 1 will be on the 23rd of October 2025 at 10 a.m. 23rd October 2025 at 10 a.m., where the bench will take the highlighting by the petitioners alongside all the others who are in support of the petitions. Thereafter, the bench will adjourn for the following day, 24th of October 2025 at 10 a.m., where highlighting will proceed on the part of the respondents and those opposed to the petition. On that very day, the 24th of October 2025, we will take rejoinder submissions by the petitioners. These directions will be accessible on the court's CTS. These are the directions. So we urge parties to comply, and we meet on 23rd for highlighting so that we get this matter off. Thank you.
My Lord, while we take your directions, I was of the humble view that the opportunity you granted us to consult with my learned friend would be factored in before you give your directions, so that my lords, my lady, we could also have the opportunity of making it known to the court about our small conference. And one honor is that I don't know whether the court is aware that is a pending appeal, petition of appeal before the Supreme Court in respect to the decision that was led by the Court of Appeal. One of the cross appeal in E032 of 2025 Supreme Court is that there are petitioners before the Supreme Court who are pursuing the question of the recusal. So that question is still pending before the Supreme Court. We do not know what or the outcome of the Supreme Court. And granted the fact that this Honorable Court has already set dates for hearing, being the 23rd and 24th, and granted the fact that we are not aware as to the outcome or the decision that the Supreme Court will render, and noting that the Supreme Court decision will be binding on this court, would it therefore, Your Honor, that I make an application to review the directions on the hearing date? My application, Your Honor, is based on the grounds that I've already indicated to the court, that perhaps the Supreme Court may agree with we the petitioners. And if it does agree, that decision will be binding on you, on this bench. We need therefore not be rendering that particular petition nugatory and an academic exercise if the court were to proceed to set a date for the hearing of the petitions when there is still a challenge of the question of recusal of that is being pursued before the Supreme Court. I think, my ladies, my lord, for good order, and so that, my lady, we can have certainty in what we are expecting or what we are doing in litigation, it would be prejudicial to we the petitioners appearing before the Supreme Court for the court to set up a date for hearing. I would propose, my ladies, my lord, that instead of us having a hearing date, we have a mentioned date in which we can come and address the court on the status of the Supreme Court's petition. I am aware Mr. Oganda must be wanting to, or Mr. Kibe must be wanting to back me up on that application, so that, my ladies, my lord, we may not be seen as if the court is rushing to overtake or to cloud the outcome of the Supreme Court. I so pray, my ladies, my lord.
Therefore, Mr. Nego, if I get you clearly,
yes,
that's an application for stay of proceedings. Oh.
My application, my ladies,
Yes.
my lords,
Yes, yes.
and perhaps they may be amended by the views of my learned friends.
Yes, before the amendment, you have to give we have to know the nature of the application.
The nature of the application is that this court ought not be seen as if it is rushing to overtake the proceedings before the Supreme Court.
There is no problem with that. We just want to understand with clarity, what is it that was seeking?
That we have, instead of having a hearing date, we get a mention date within which we can address the court on the status of our cross appeal on the recusal application.
Okay.
And whether or not, if the court does go ahead to hear this application, your actions will be rendering the petition before the Supreme Court nugatory and an academic exercise. Those are the two applications. And the last one is the most important one because that requires the determination of the court.
Good afternoon, Your Lordship, Justice Ogola, Mr. Mrima, Justice Mugambi. We have an order from the Supreme Court, and this is an order in petition E032 of 2025. The Supreme Court, this is an order from the Deputy Registrar of that court. We the parties before that court on a petition and a cross appeal have been given strict timelines to file and submit. I think the last day will be tomorrow, which means the court is acutely aware of the real urgency in this matter, and our suspicion is that the court will give us a fast-tracked hearing date. That's
in petition
number E032 of 2025. That being the case, the matters before the Supreme Court are jurisdictional. They may reverse the Court of Appeal. They may affirm the Court of Appeal. So that this court does not engage in an academic exercise, it is our humble request that the directions given a few minutes ago be stayed, and as my good friend Mr. Ndegwa has prayed, we do have a mention date to confirm if we have an expedited date at the Supreme Court or whatever decision the Supreme Court will decide before this court proceeds with the hearing of the substantive suit. It is for purposes of judicial economy that we hear from the Supreme Court, and that will guide the court here in terms of how to proceed. It is a humble prayer. Thank you, my Lord. Thank you, Your Lordship.
Mr. Okada, just clarification.
Yes, Your Lordship.
Do you also have a date before the Supreme Court?
We have a date for confirming compliance.
When is that?
It was on 25th. That has been overtaken by then. So we have a final extension by tomorrow. Then we have a date before the court. We are yet to be given.
So at the moment, you have not been given a date.
We don't have a
appear next before the court.
Yes.
Yes.
My Lord, yes, the only thing that we would like to draw to the attention of this court is that there are several decisions in which the Court of Appeal has held that even where there is no an actual stay that has been granted or sought, the moment the High Court, they all related to decisions of the High Court, is made aware that there is proceedings pending before the Court of Appeal that may have a bearing on the High Court proceedings, that it would be prudent for the High Court to await for the conclusion of the proceedings before the higher court, so that upon the petitioners informing this court that there are jurisdictional issues that are yet to be resolved, I submit that it would be prudent that hearing dates and further proceedings should not be undertaken. I think that's as far as what the discussions we had with Mr. Ndego and my learned colleagues, that needs to be understood that way. The only other two issues arising away from that is that we have seen the court's indication that the petitioners' cases be heard within a day. I believe we had some discussions. This matter is unprecedented across the world. The issue of the impeachment of a deputy president. The nature of the petitions that are before you, it is a humble view that a day for the petitioners would be grossly inadequate. I don't know about the respondents, so the minimum period that you would be asking would be 2 days. But that is when we come there, which will affect the issue of the time allocation that is to be given. And as regards the issue of whether or not a formal application for stay ought to be made, that one is something that can still be made if that were to be the directions of the court. But we take it that we have informed the court of the rule of prudence, that there are proceedings or before higher court that have a bearing on the jurisdiction of the court. You're most obliged.
Your Lordships and my lady, when you retired, Your Honor, Your Lordship, I had indicated that I had an application that was on record, and I've taken the liberty, Your Lordship, to have the application with your assistance.
The name again?
George Sakim, for Your Lordship. I do appear for the 4th to 8th petitioners. Your Honor, I had indicated that last time the court had said it will give directions on my application today, and Your Lordship, on your directions, I haven't had any directions in terms of my application, which is still on record. And Your Lordship, I do pray that I'm given direction. It is a notice of motion application dated 28th of May. 28th of May. 28th, Your Lordship.
What does it?
Yes, Your Lordship, the prayers that it seeks are inter alia that pending the hearing and determination of the petition, an order be and is hereby issued compelling His Excellency Kithure Kindiki to immediately cease acting and holding out as Deputy President and or performing the functions of the Deputy President of the Republic of Kenya. This is in light of the Court of Appeal decision, and therefore, Your Lordships and my lady, I do pray that I'm given directions on this application. It has been on record since May, and I do pray that the same be.
In which petition is it?
It has been consolidated, but it's in Kerugoya E015.
Okay, good.
Again, my lords and my lady, I rise once again on that clarification. And unfortunately to me, it seems to have muddied the waters even more. Because from what I have heard is that the applications in Kerugoya were overtaken by events because of the ruling of the Court of Appeal. As I understood the ruling of the Court of Appeal, the empanelment was quashed. meaning that what we would call the October bench.
Mr. Muge,
Yes.
I think it will be very untidy for you to argue with the bench on the direction who the bench has made. It will be very untidy because we make a ruling and we cannot then be called upon to argue over those rulings. I don't think it will be, because we also made a concise ruling. I think the proper thing is, if you don't agree with our direction, you move the court properly. Otherwise, we cannot respond to you.
Okay. I understand, my lord. What I meant to ask at the end of that was, the court has said that the ruling of this court in regard to those applications. My clarification had sought to know what court or bench made any rulings on those applications. That was the main purpose of that clarification. If there was a ruling made by this court, when was this ruling
made?
made?
It very clearly that those matters were overtaken by events arising from the ruling from the Court of Appeal and the ruling which we made in this particular court. Those rulings are on record, and therefore I'm saying it will be very untidy for us to, you and us, to argue over those rulings. If the directions are not proper, you know how to move the court.
No. My lord, that is now on record, so that's what I'm going to say. Much obliged.
Yes. Any other issue?